Detention under Republic Act Number 9372. Number 1. What is Republic Act Number 9372? It is an act secure the state and protect our people from terrorism. This act shall henceforth be known as the Human Security Act of 2007. This law was amended by Republic Act Number 11479, otherwise known as the Anti-Terrorism Act of 2020. Number 2. Does the time of delivery of detained persons prescribed in Article 125 apply to suspected terrorists who are detained under Republic Act Number 9372? Any person charged with or suspected of the crime of terrorism or crime of conspiracy to commit terrorism shall be delivered to the proper judicial authority within the period of 3 days counted from the moment the said charged or suspected person has been comprehended or arrested, detained and taken into custody by said police or law enforcement personnel, without the police or law enforcement personnel having said person in custody incurring any criminal liability for delay in the delivery of the detained person to the proper judicial authority. However, the arrest of the suspects must be resolved from the surveillance under Section 7 and examination of bank deposits under Section 27, Section 18, RA number 9372. Ang taong dinimanda o suspetsado sa krimen na terorismo o ang krimen na conspiracy to commit terrorism ay kailangan masampahan ng kaso sa loob ng 3 araw mula noong ang dinimanda o suspektadong tao ay nahuli, kinulong at inilagay sa kulungan ng mga pulis o alagad ng batas na hindi nakalagay sa kanila na pananagutan kriminal sa pag-antala ng pagsampa ng kaso sa korte. Subalit ang paghuli ng mga suspect ay kinakailangang bunga ng pagmamatsyag sa ilalim ng Section 7 at pagsisiyasat sa mga deposito sa bangko sa ilalim ng Section 27, Section 18, RA 9372. Under RA 9372, who must be notified before a suspected terrorist is detained. Before detaining the person suspected in the crime of terrorism, the police or law enforcement personnel concerned must present him or her before any judge and the letter's residence or office nearest to the place where the arrest took place in any time of the day or night. Bago ikulong ang taong suspektado sa krimen na terorismo, ang mga pulis o alagad ng batas ay kinakailangang maipresenta siya sa kahit sinong huwes sa lugar na kung saan nakatira ang hinuli o sa opisina na pinakamalapit na lugar kung saan nangyari ang paghuli o kahit anumang oras sa araw o gabi. It shall be the duty of the judge among other things, the ascertain the identity of the police or law enforcement personnel and the persons they have arrested and presented before him or her to inquire any of the reason why they are having arrested the person and determine by questioning and personal observation whether or not the suspect has been suspected to any physical, moral, and psychological torture by whom and why. The judge shall then submit a written report of what he or she had observed when the suspect was brought before him to the proper court that has jurisdiction over the case of the person arrested. The report shall be submitted within 3 days, calendar days from the time suspect was brought to his or her residence or office. Isa sa mga tungkulin ng huwes ang pagtino sa pagkakailanlan ng mga pulis o alagad ng batas at ng tao o mga tao na hinuli nila at hinanap sa kanya para matanong sa mga kadahilanan kung bakit nila hinuli ang tao at alamin sa pamamagitan ng pagtatanong at at personal na obserbasyon kung ang suspect ay nilagay ba sa pisikal, moral o psychological na pagpapahirap sa kanino man at bakit. Ang huwes ay dapat magbigay ng nakasulat na ulat sa kanyang obserbasyon kung kailan ang suspect ay dinala sa kanyang harap patungkol sa kaso ng pagdakip ng tao. Ang ulat ay dapat ibinigay sa loob ng 3 araw sa kalendaryo mula noong ang suspect ay dinala sa kanyang tirahan o opisina. Immediately after taking custody of a person charged with suspected of the crime terrorism or conspiracy to commit terrorism, the police or law enforcement personnel shall notify in the judge of the court nearest by the nearest the place of apprehension or arrest provided that where the arrest made during hours. The written notice shall be served at the residence of the judge nearest the police where the accused was arrested. Kaagad-agad pagkatapos ng pagkulong ng taong dinimanda o suspektado sa krimen na terorismo o conspiracy to commit terrorism, ang mga pulis o alagad ng batas ay magsasabi sa pamamagitan ng pagsulat sa huwes ng korte sa pinakamalapit na lugar na ginawa ang paghuli. Dapat na kung saan ang paghuli ay ginawa sa panahon ng Sabado, Linggo, Kapistahan o pagkatapos ng oras na pag-opisina. Ang nakasulat abiso ay kailangang maibigay sa tirahan ng huwes sa pinakamalapit na lugar kung saan akusado ay hinuli. The penalty of 10 years and 1 day to 12 years of imprisonment shall be imposed upon a police officer or law enforcement personnel who fail to notify the judge as provided in the preceding paragraph, section 18. Sa parusa sa 10 taon at 1 araw o hanggang 12 anyos na pagkakulong ay ipapataw sa pulis o alagad ng batas na bigong ipaalam sa huwes ayon sa nakasad sa naunang talata. Section 18. Number 4. What is the period of detention in the event of an actual imminent terrorist attack? In the event of an actual imminent terrorist attack, suspect may not be detained for more than 3 days without written approval of municipal, city, provincial, or regional office of a human rights commission or judge of the municipal. Regional trial courts, the Sandigan Bayan or the Justice of the Court of Justice of the Courts of Appeals nearest in the place of the arrest. Sa panahon ng aktual na sa puntong pangyayari ng terorismong pag-atake, ang mga suspect ay hindi pwedeng makulong sa lagpas na 3 araw na walang nakasulat na pahintulot mula sa munisipyo, panglungsod, pangprobinsya o rehiyon sa opisyal na Human Rights Commission o huwes sa munisipyo. Regional Trial Court, Sandigan Bayan o isang mahistrado ng Court of Appeals na pinakamalapit sa lugar na ginawa ang paghuli. If the nearest was made during Saturdays, Sundays, holidays, or after office hours, the arresting police or law enforcement personnel shall bring the person thus arrested in the residence of any officials mentioned above is nearest the place where the accused was arrested. Kung ang paghuli ay ginawa sa panahon ng Sabado, Linggo, Kapistahan o ang pagkatapos ng pang-opisinang oras. Ang humuling pulis o alagad ng batas ay dapat dalhin ang taong hinuli sa pamamahay ng alinman sa mga opisyal na nabanggit sa itaas na pinakamalapit na lugar kung saan ang akusado ay nahuli. The approval of the writing of any of the said officials shall be secured by police or law enforcement personnel concerned within 5 days after the date of detention of a persons concerned, provided, however, that within 3 days after detention, the suspect whose connection with a terror attack or threat is not established shall be released immediately. Section 19. Ang pahintulot na nakasulat sa alinman sa mga nabanggit na mga opisyal ay kailangan maitago ng mga pulis o alagad ng batas na uukol sa loob ng 5 araw pagkatapos ng petsa ng pagkakulong ng mga taong naiukol. Subalit, sa loob ng 3 araw pagkatapos ang pagkakulong ng suspect, ang kaugnayan ng terorismong pag-atake o pananakot ay hindi napatunayan, kailangan siyang palayain agad. What is the penalty for failure to deliver the suspect to the proper judicial authority within 3 days? The penalty of 10 years and 1 day to 12 years imprisonment shall be imposed upon the police or law enforcement personnel who has apprehended or arrested, detained, and taken into the custody of person charged with or suspected with the crime of terrorism or conspiracy to commit treason, and fails to deliver such charged or suspected person to the proper judicial authority within the period of 3 days. Section 20. Ang parusa na 10 taon at 1 araw hanggang sa 12 taong pagkakakulong ay dapat ipataw sa mga pulis o alagad ng batas na humuli at nagkulong sa taong dinimanda o suspetsado sa krimen na terorismo o conspiracy to commit terrorism at nabigong magsampa ng kaso sa korte sa loob ng 3 araw.